All right, we're going to address sentencing. Before we do that, I want to see if there's any disagreement as to merger of the charges or vacating any of the sentences because of the. I know that the aggravated battery charges merge with the felony murder charges, and I believe the cruelty to child does as well. But I want to see what both parties indicate.
No, sir, I don't think we agree.
Okay, what is your position on that?
The state's position is that, of course, the court could impose sentence on. That you go straight down the line. The court could impose sentence on count 2, which is felony murder. Count 3, felony murder, would be vacated because you can't be sentenced for 2 murders in the same case when there's only 1 victim. Count 4, aggravated battery, would merge with count 2, felony murder. Count 5, aggravated battery, would stand alone because you would only merge 1 felony with the felony murder, not 2. Even though the felony murder, because the felony murder is. Well,
can I see the indictment? Will you hand me up the indictment from the?
I mean, I have a copy of it. I don't know. I guess
it's with the exhibits.
Is it in that box?
Well, if you have a copy, that'll be just as fine. Well,
I just counted all the exhibits. I didn't even think about that.
I don't know. I do have.
You can hand it up. That's fine, Laura.
I do have a copy.
All right.
So
let the court reporter sit back down.
yes, sir. Yeah, please.
All right. Let me ask you this question. Felony murder in count 2 charges her with murder based upon the commission of aggravated battery by causing blunt force trauma to the head and torso, right?
Yes, sir. But that "and" is interpreted disjunctively, and I mean.
Let me finish my thought pattern,
yes,
and then
sir.
you can tell me your response to that.
Okay.
Count 4 charges her with aggravated battery by rendering his brain useless, and count 5 by rendering his liver useless. And then count 2, felony murder, charges him with aggravated battery for both of them. I mean, in either way, right? To the head or the torso. So why wouldn't both merge into count 2?
But first of all, with respect
Can we
to
take a break? Are you looking for the indictment?
Yes.
Okay. If it's not in there, then they need to hold everything in that. Okay. All right. All right. Okay. You can go ahead.
so even though which count is the count 2 is the one that relates to the aggravated batteries?
Yes.
Is that right?
Yes.
Okay. And so it refers to an aggravated battery based on damage or whatever to the brain and to the liver. That
Head and torso.
Or head and torso, right? That "and" is should be interpreted disjunctively. In other words, if there was a finding that only a battery to the head, that would be sufficient to support a claim. A finding of guilty on felony murder. If there was a finding of aggravated battery only on the torso, that would be sufficient to support it. So since either of them will support the felony murder, only one of them merges, and then count.
How do I know which one merges?
First one. If you go straight down the list of charges, okay, and you get count 3 is vacated, count 4 merge with count 2, and then now there has been a merger for count 2, which means count 5 would not merge; it's left freestanding, and count 6 can't merge because count 3 was vacated. So the sentence should be on felony murder and on count 5 aggravated battery and count 6 cruelty to children. That is the state's position.
All right, Mr. Gamble.
Yeah, we disagree on that interpretation. I believe that the court is correct concerning the merger of the aggravated battery. That the only charge that should stand is the first count of felony murder, which is number 2. And then the others would have merged in one way or another and be out. And then the only other charge could be cruelty to children. I believe would be the only one that remained with the felony murder. That's our position.
Do you happen to have any case law that addresses this
If you-
particular situation?
Yes, sir, if you, I mean, if the court wishes to take it.
Maybe we should take a recess.
Well, if,
because I
I'm
thought-
looking right now, Judge.
Okay. And I did say, I mean, you do agree that then the felony murder, the 2 felony murders, 1 vacates, right?
Yes, sir. Count 3 is vacated. That's correct.
Okay. But the fact that count 6 would have merged with count 3 doesn't affect count
No,
3?
sir. Once it's vacated, then there is nothing for it to merge with.
Okay. So the question is, and I think Mr. Gamble agreed with that, the question is whether count 4 and 5 merge with count 2, because the felony murder charge in count 2 included both, whether it's, I guess it says and, you say that says is the disjunctive, which means or.
Right.
But it includes count 4 or 5 or 4 and 5. I mean, they could have found him guilty of both. Well, they did. They did find her guilty of both. So I guess I need case law on that. If the state is seeking a sentence on aggravated battery count 5. So we'll take 30 minutes. Mallory, you come with me, and we'll take. I'll give you some. I'll alert you when I'm ready to address that. All right, I'm being told that the state and the defense agree that the sentence that the court is going to impose is for counts 2 and count 6.
Yes, sir. I advise Mr. Gamble that after doing some additional research, or some initial research rather, on that particular question, that I think that 4 and 5 would merge with count 2, and that being the case, the state's position is that the court should sentence on count 2 and count 6, which I understand is the defense position as well.
Correct.
Yes, sir.
Yeah, that's what I was finding too. I had never seen a case where you could back a charge out of the felony murder, even if it was. Of course, there's very few cases where more than one felony are charged in a single count of felony murder. But at any rate, then count 3 will merge. Will be vacated. Count 4 and 5 will merge with count 2, and count 6 is a standalone offense based upon the merger of count 3. The vacation, the fact that count 3 had to be vacated. Is that correct?
Yes, sir.
All right. I'll hear from the state concerning sentencing as to count 2 and count 6, and of course, if you want to present any witnesses, you certainly can. And I believe the sentence possibilities are life on count 2 or life without parole, and on cruelty to children in the first degree, the sentencing range is 1 to
5 to 20.
5 to 20. Okay. All right. I'll hear from the state first.
Your Honor, the state proposes that the appropriate sentence in this case would be a sentence of life in prison on count 2, with a sentence of 20 years consecutive on count 6. I understand that Ms. Poague is very young. I think this is the terrible tragedy of these kinds of cases. I have a baby as a victim and who was at the time a teenager as the defendant, and I think that the jury's verdict. It's not always very possible to get an interpretation of what the jury might have been thinking. But I think if you look at the way the verdict is structured, that it suggests to me, at least, that by finding a not guilty on malice murder, that there was a belief that there was not evidence of a specific, essentially a specific intent to kill or a deliberate intention to kill, and that would be the distinction between count one and the remaining counts. And so, in my view, if I accept that as a finding of fact, from my perspective in proposing a sentence, if I consider that or accept that as a finding of fact of sorts, that there's evidence of malice, that there's evidence of disregard, conscious disregard for the consequences of her actions, then I feel justified in asking for consecutive time. But if I do not believe that the evidence supported this jury in making a finding of a deliberate intention to kill, such as would support a malice murder conviction, then I feel constrained to leave the recommendation at life without parole. At life in prison as opposed to life without parole.
All right. Do you wish to present anything? Anybody wish to say anything from the family, or are you presenting any testimony?
No, sir. We're not presenting any testimony, and I'm not the father of the child is not father and aunt are here, of course, but I'm not asking them to make statements to the court, and I've told them both that they could if they wanted to do so, but we're not going to.
Okay. Mr. Gamble?
We recognize felony murder. I don't think if they're recommending life with parole, that's as lenient as a sentence could be under that particular charge. I don't think you can go below life in prison for a felony murder charge.
Right.
So we don't dispute that. We would ask, though, Your Honor, the cruelty to children, they're asking for consecutive 20 years. If you put that on there, you're coming very close to being life without parole, in that she will not come up for parole currently for 30 years and then add 20 more to it. Would be very close to her entire lifetime. And we would ask the court to consider, you've heard the evidence and you know generally what the whole circumstances were. She was 18 years old at the time, a young girl that had not had any trouble with the law, any problems, and was doing well. Now, obviously, she's accused of a horrendous crime that we fought about in court, but we accept the jury has made a verdict, whether I agree with it or not. So she has to now face what the consequences are of that. But it should not be so severe that it would be akin to life without parole. And that would be what happens if you make this consecutive serving time sentence. So we would ask that on the cruelty to children that it run concurrent with the life sentence that she is going to be imposed on her for the felony murder. So felony murder plus 20 years, but run concurrent with the felony murder charge. Yeah.
All right, Ms. Poague, if you'll stand up, please. I don't do a lot of speaking when I'm passing the sentence. I've heard the case, and I've considered the tragedy on the left side, on my left side, and on the right side, and there's a lot of tragedy to go around here. The whole time that I'm hearing a case, I think about what the appropriate sentence would be. And this conduct all led, in my opinion, to the offense of felony murder, even the charge that, would have merged with count 3, but does not because count 3 is vacated by count 2. That's a lot of technical jargon. But The bottom line is you're going to receive a sentence of life in prison, which is the appropriate sentence for the conduct that you have been convicted of. And that is going to essentially be the sentence that the court passes in this case. You will be sent on, so on count 2, I sentenced the defendant to serve life in prison. And on count 6, I sentenced the defendant to serve 20 years in the state penitentiary. Those sentences will run concurrent. I do wish to advise you, Ms. Poague, that you have 30 days to appeal. You also have 4 years within which you could seek habeas corpus. I hope this can bring some closure to the family. It's just a complete tragedy. And I hope that you can, in your older days, have some sort of life after serving this sentence. And life while you're in prison. I guess you just have to make the best of it. But that's the sentence of the court. I wish everybody the best.
Forward it to Mr. Gamble for review, and then to Your Honor.
Thank you.